every winter.
All right, this is the Cowlitz County Minor Guardianship docket. And make sure that you are here on that matter. 8, minor guardianship of Emma Ryan.
Good morning, Your Honor. Josh Good Day here. I believe my client Lauren Ryan is here on Zoom with Emma Ryan.
Morning, Your Honor.
Morning.
Morning, Your Honor.
All right. I want to know why mom is not here in the courtroom with the minor child, and since that was the order.
So, Your Honor, I spoke with them. They were getting train tickets. They were planning on being here. 2 issues. One is the weather. The second issue is my understanding is Emma has made some um, concerning comments about not wanting to go to the English's house. So they're getting her some counseling from what I understand. So she's here on Zoom. I know the court's worried about her, so that's where we're at, Your Honor.
Okay. Well, I don't want a minor child listening to this. That's not appropriate. Mom was to have the child here in the courtroom. I understand that there have been some issues because of weather at the same time. So the minor child needs to be moved to some other place other than listening to this hearing.
And Your Honor, I also think it's important to note that Miss Ryan had up until today to give the child to the Englishes. I think the weather issue is immaterial. If the deadline was today, she could have done it at any other point until now. So I think that we should still be moving forward with the warrant as the court ordered.
You're free to go. Thank you. All right. So hold on. So where is mom coming from?
It looks like she might be trying to unmute.
Tacoma, Washington.
Okay, well, sir, can I help you?
Yes, I'm at court. I believe it's 10:30.
What court do you have?
I thought it was district, but the attorney out here just told me that it's superior. I don't know if that's
okay.
Correct.
What type of case?
It was
criminal case?
Yes.
Okay, this is not where you need to be.
Sorry.
Just go. I think they're down in courtroom 1. Okay. So keep going that way.
Thank you.
Okay. Sorry for the interruption. So that I have an issue with. I know that the trains were not running when it, as far as going south, but I'm not aware the train's not running between here and Tacoma.
So my client was also concerned because now that Emma's out of the room, apparently Emma's made suicidal comments. If she has to go to the Brooks or the English's house, that she's gonna kill herself. So they got her into mental health counseling. My client's just concerned about turning her daughter over. I guess she's more worried about her daughter's health and life than complying with the court order at this point. She just wants a guardian ad litem and a full investigation done.
Your Honor, we'll object to this. This has never been brought up before, and it's conveniently being brought up the day that Miss Ryan's supposed to give Emma over to our clients with the risk of having a warrant issued. I also think it's important to note Miss Ryan has now missed a court hearing in Oregon, and a warrant is out for her arrest elsewhere in another matter. So I think it's pretty obvious to the court, Your Honor, that she's just trying to buy more time. This has never been addressed before until now.
Well, Your Honor, she told me that she was getting ready to turn Emma over and said, and it was at that point where she said, "Sorry, I have to do this." And that's when allegedly Emma made the comments. Also, my client told me that one of the English's children, I guess, was arrested recently over the weekend. So she's worried about putting her in a home with that situation. My client's just concerned about turning her daughter over. And
Your Honor, we're objecting to any of this. This has never been brought before, and that's not factual. Miss Ryan is just merely trying to find reasons not to comply with the court order, which she hasn't complied with since October of 2023.
May I speak, Your Honor?
No, just so bottom line, there's a court order. I understand the concern when it comes to a child if they're threatening, if that's even occurring. I'm having a hard time just because of the evasiveness of what's been going on, of even believing what's being said. But I agree with Mr. Flay that none of this to just all of a sudden have this on today when she's supposed to be standing here in this courtroom. Everything was set up for her to appear with the child today. Any kind of mental health matter can be dealt with by counseling with the Englishes. I'm not aware of any child being arrested, the family of the Englishes. And Mr. Flay, I don't know if you want your client to address that or not.
Again, Your Honor, I think to echo the sentiment you're saying that any of these issues can be dealt with after the placement's been done. That's priority number one. Having said that, I'm not aware of this issue. If Brooke English wishes to speak to it, I'm happy to have her speak to the court now.
Go ahead.
So I'm happy to speak to the court. We actually have a counselor set up for Emma for when she comes to live with us, as well as a tutor for her ready to go once she's placed in our care to catch up with her schoolwork. We have two children at our home. One is 16, one is 18. They are both amazing students at school. Nobody has ever been arrested. One is a varsity basketball player en route to go to college when he graduates this year. The other is a National Honor Society straight A student. It's a Seaside High School. Never have they ever had police contact. They are amazing children that volunteer in their community. And this is just another bold-faced lie that Miss Ryan has tried to come up with to really like put us on blast and to disparage our reputation. And it's sickening. And, you know, she's done this with our other child saying he's been sue himself at school, which was another bold-faced lie. These are my children, and she needs to quit putting this out there. This is horrible. My kids need to be protected from her.
I'll just stop you there. Thank you. Mr.
Your Honor,
Flay,
may I?
Mr. Goodday, go ahead.
Just that my client sent me something from Clatsop County saying Adam English was booked on January 15th. I don't know if that clarifies anything.
I'm done with the subject. I'm done with the subject. This is not properly before the court. Just stop. This is not properly before the court. And to suddenly come up, bottom line is you were ordered to be in this court today with that child. You are not here. I am issuing a warrant for your arrest. So it is up to you, and you can take care of that by turning that child over. Things are set up for the child and the child's safety. I expect you to comply with this court's order. Bottom line.
Can we know the actual whereabouts where Miss Ryan is so my clients can at least try to reclaim the child themselves if need be? And if Miss Ryan's not going to comply, what does the court want to order her to do to surrender Emma at this point? Are we going to have a new location pending while the warrant's still out for her to give Emma to the Englishes? I guess just trying to figure out what to do procedurally secondary to the warrant issue.
Mr. Goodday?
I don't have any information on that, Your Honor, so I'll defer on how the court wants to proceed with that.
Your Honor, Miss Ryan's here, so she could say where she is.
Ms. Ryan?
I'm a part of the confidentiality program in Washington State. I still have a lease, and I don't feel comfortable. I'm a victim of domestic violence. I don't feel comfortable saying I'm public where I'm at. I don't think that's appropriate. And I believe being a part of this address confidentiality program by the Secretary of State, that I'm allowed to be protected.
I'm not aware. I have not been provided any statement that shows that you are part of that program, but there's nothing that stops you from texting your attorney and that attorney giving it to Mr. Flay.
And Your Honor, could we ask that the court order she must provide us the address of her whereabouts immediately upon drafting this court order?
I want the address of where the child is located. The child is located. And that is to be turned over immediately. I want you to text it now to Mr. Gooday of where the child is located. And that will be turned over to Mr. Flay. If in fact that information is provided to Mr. Flay and the child picked up, I can be notified and I will quash the warrant. But if that doesn't happen, that warrant will be outstanding.
And Your Honor, regarding the order from last time, I know there's a lot of moving parts, so it is difficult to get everything going, especially with the weather. But I don't believe we were able to get the court's order last time extending the emergency minor guardianship. We would ask today if the court is re-extending that, and if so, can we have it be to February 29th so my clients can file the certified order of that in California for their separate matter down there.
Mr. Gooday, anything?
Not on that, Your Honor. I know at the last hearing we did speak about a guardian ad litem, and I think you told us to bring it back up. So I don't know if you wanted to still address that today or not.
So the guardian ad litem, well, how old is the child?
13.
She's 13.
Okay. And trying to determine whether it should be a guardian ad litem or a court visitor, but it sounds like it should be a guardian ad litem.
And Your Honor, also, I guess another issue is we have been.
So let me finish up what you originally were asking, Mr. Flay. I didn't hear any objections to setting it over to the date that you were talking about. And so in regard to that date, that go ahead and get me an order and to have the language as well for California, if that needs to be included.
Understood, Your Honor.
Your Honor, I'd like the record to note that Jared Johnson, my abuser, is in the courtroom right now.
Your Honor, his name is on the roster. I don't see how that's relevant or what Ms. Ryan's asking for.
I think it goes to Ms. Ryan's claim that this is a coordinated attack where they're trying to harass her.
So the only people in the courtroom are the Englishes and a lady. I don't know who that is. But,
he's on the Zoom call, Your Honor, Jared Johnson.
And that's why I said she texts it to you, and then that address be text to Mr. Flay. So I'm not having her state it verbally, but I do want it text to Mr. Gooday and Mr. Gooday to text it to Mr. Flay. I expect that to be done.
And Your Honor, the last big issue that we had was the timeline. So the emergency minor guardianship was ordered over 100 days ago now. The concern is that generally they would expire after up to 120 days. If we're pending the general minor guardianship, I know the court, the intention of the emergency minor guardianship is to have it exist pending that. Are we expecting that the general minor guardianship orders will be, at least temporary orders will be issued? Or are we going to basically just have the emergency minor guardianship go out past the 120 days?
I think at this point, Mr. Gooday, I don't know if you have any thoughts on that.
Yeah, I mean, I think the purpose of the emergency is to put a safe spot for the child while the general is taking place, but I think it makes sense that we should get moving on the general guardianship, but I don't know what your honor was going to say. I know you had a thought.
Well, the problem is that we can't even move forward, and that's being done specifically and intentionally by your client to interfere with the court process by failing to provide the child, failing to provide the address as directed. And so she's intentionally delaying this process. So at this point, I'm inclined to go ahead and just extend the emergency guardianship one additional time, and then we can move forward with what we have at that point.
And my understanding is that my client would comply with the guardian ad litem in the full investigation. She just does not want to turn Emma over pending the investigation.
Well, she doesn't have that choice. Court order has directed her to do something, and she's failing to do it. So I'm not going to do things what she decides and wants when she doesn't cooperate and intentionally interferes with this court's order.
We have only had immediate emergency orders in place. There's not an emergency order.
Okay. I'm not sure what happened there. All I can figure is with the weather, maybe something happened. So if you could get me, Mr. Flay, an emergency order that I can sign. I'm not sure. You can make it nunc-pro-tunc to the last hearing, so it's covered.
Okay. And Your Honor, I'm assuming with the weather that we're okay again to do an email of that.
That's fine. I think you got hit worse down south than we did.
I'm actually not in the state of Oregon anymore in another weather storm on the East Coast. So
okay.
all bad all around. But we will get that sent over to you shortly after this hearing.
Okay. All right. All right. So at this point, let's go ahead and get looks like the next person is Amy Turnbull. And then we'll need to get the warrant issued. Well, as long as you're sending me orders, can you do the guardian ad litem order and Ms. Gooday, is that okay with you? I know you're essentially asking for it.
Yes, Your Honor. Thank you.
Okay.
Understood, Your Honor. And just to clarify, I'm just doing an updated emergency minor guardianship. We're not doing any sort of temporary in the general guardianship.
Well, what do you think? What are your thoughts at this point?
Your Honor, my only concern is, and also we're kind of in a weird, uncharted territory. I don't think most of these ever go this far without a placement. But my just concern is statutorily, if we're outside the time frame for an emergency minor guardianship, I don't know if the authority exists to expand it beyond that timeline. So that's my only concern, is that if we push this out further, then this might create an issue for my clients down the road.
Mr. Gooday, anything?
Just that, my client's entitled to a hearing on the full guardianship, so I would object to like transferring it or converting into that at this point.
And Your Honor, we're not suggesting that. I think we just haven't even taken any steps because of all the issues with the emergency minor guardianship. We'd be absolutely fine having a hearing, but no hearing's been set, because the original hearing for the 4th, I believe, was actually Judge Basher's setting of the general minor guardianship review, which became superseded by the contempt motion on this, which obviously has become the focal point of the case until now. So I think having an initial hearing is absolutely okay. We just need to have that hearing, which, again, as I said before, was what this set of hearings was originally set for.
And if I understand correctly, Mr. Clay, you're proposing a temporary order at this time, and that a hearing would be set after that for the full. Is that what I'm understanding?
That would be, I think, appropriate, Your Honor, just to avoid any lapsing issues with the emergency minor guardianship timeline.
Okay, because I do agree with Mr. Goudet, and I don't think you were disputing it, that she has a right to the full hearing. But at this point, without a guardian ad litem investigation and a report, I certainly wouldn't want to push forward on that. And without the child being placed as ordered, that interferes with the entire process. So I'll sign the temporary order.
Okay, Your Honor, we'll prepare that as well as the other two you've requested.
Okay. All right. And just to make sure, the emergency order, I think it just, like I said, because of the closures and what's gone on here, just get that and do the non-pro-tunc language.
Understood, Your Honor.
Okay. All right. I think as far as that matter, I don't think there's anything else today. Counsel, anything?
Your Honor, I guess for the, we'll just be pending the full minor guardianship hearing until the guardian ad litem report's been done.
Correct.
Okay, understood.
Your Honor, I just got a text from my client. She said that her other attorney that she hired is in the waiting room, and she wanted him to speak.
Your Honor, we haven't received a notice of appearance. Mr. Goudet is the attorney of record.
I think it might be one that she hired in a different state.
Even
okay, well, unless they're licensed in the state of Washington, and I've let everybody in, so I'm not aware of anybody.
Your Honor, I just got admitted to your courtroom, and I am having my petition for pro hoc vici drafted and sent up for the court's consideration. If I may address the court, I can perhaps shed some light on some of these things.
Okay, well, at this time, sir, you're not admitted into the court, so I won't be hearing from you today. All right, so I think everything for today is done, and we'll address at the next hearing.
Thank you, Your Honor.
Your Honor, Hannah Cowden, attorney for petitioners and minor guardians, emergency minor guardians.
Morning, Your Honor. Donald Esau on behalf of Katrina Vorse, the mother of the children.
Jack Carnahan, Jessica's father.
And Katrina Vorse, her mother.
Okay, thank you.
Mike and Carla Vorse, guardians.
Okay. So at this time, I just received about 5 minutes before walking on to the into the court a large stack of documents. I don't even know who they're from. And I have not had any opportunity to review those documents at all. So I'm not even sure who submitted them.
Your Honor, that's that would be us. That's a full petition for guardianship. Today, we would ask the court to be extending the emergency temporary guardianship. We would like the court to hear from Tina Day, as she was able to meet with my clients this week. And then I would defer to the court whether or not you want to discuss the full petition today or set that for a hearing at a different time.
So, Ms. Day, have you had a chance to do everything, or where are you at with things?
So I have not had a chance to do everything, but I have met with the petitioners, met the child, met with both of the mother and the alleged presumed, whichever legal term is correct for the father. I've talked with the social worker and mother's DOC officer. So I have some information to offer, but I would need additional time to finish this investigation completely.
I don't want Ms. Day to have to report when she doesn't have what she needs done. So I don't think that'd be appropriate for today. And then, so at this point, I would look at the extension of the emergency guardian order. Mr. Esau, am I saying that correctly? I'm never quite sure.
You are, Your Honor. Thank you.
Okay.
Yeah, my client's concerned about visitation right now because she's only seen the child who's 2 years old one time in the last 3 months, is my understanding. And I think one of the purposes of the hearing today was to hear from Ms. Day about whether or not more visitation is warranted. On my client's side of the ledger, she has a December 18th or 8th, 2023 drug and alcohol assessment, says she's fine. There's no symptoms. There's nothing going on at this particular point in time. The child apparently was placed initially with the guardians before they were guardians because she was going to be serving some jail time. And then after she came out of jail, then she was faced with this emergency petition for guardianship. So I don't believe we have any formal visitation in place yet, but my client believes it's appropriate for her to have the opportunity to meet with the child at least a couple times a week. This is obviously, this is a very young child. She's bonded with her mother. She's with people that are concerned citizens for sure, but I don't think they know the child very well. And I don't know if there's been any bonding since the child went to stay with them at this particular point in time. So we would ask for visitation a couple times a week, maybe Wednesday evening and a Sunday afternoon, something of that nature. Not supervised because there's no risk to the child here. It may be appropriate if the court is still concerned about the drug and alcohol issue, that there may be some sort of UA prior to meeting with the child, or at least one a week, or if that's appropriate, if the court thinks that's appropriate. My client doesn't think
that happened after the last visit, and upon seeing pictures of herself with her mother. There is a appointment with the Progress Center for the child, I believe, next week. And we would like the opportunity for the child to be seen by the counselors there before visitation occurs. We are also requesting in our residential schedule as part of the full petition that visitation be a subject that's revisited once the parents have shown that they've entered treatment for substance abuse after a full evaluation.
Ms. Day, do you have any thoughts at this point?
I do, Your Honor. So I've had a chance to talk with the social worker, the parents, and mother's DOC officer, and certainly substance use is a concern and is an active concern. I think mother needs to have a new evaluation as requested by her DOC officer because of a positive UA. Both parents admitted to infrequent but occasional use of substances that would give concern for this child's safety. I do think visits would be appropriate. I would recommend maybe one visit supervised a week. The library was a place that was used prior, and I think that's a great option and allows me an opportunity to observe the child with the parent, but it's safe. I do think a UA would be appropriate before visits to make sure that there was no risk of exposure of this child, because that's definitely one of the allegations that is involved in this petition for serious substances that could harm this child. So I think visits are appropriate, but I do think it needs to be limited, and I think the parents need to be able to verify that they would be appropriately clean at the visit. So a UA before would be appropriate. Supervised could be done by a third party. I think there's a couple of options. I know mom and dad were thinking of some individuals. I know the petitioners might have a name or two, so that it would be a neutral person, but it should not be anybody who currently lives or resides with the parents because of the circumstances there and the concerns that have been raised, and I haven't had a chance to fully vet those individuals.
So, counsel, you said that the child was going to, I'm going blank on the name.
The Progress Center, Your Honor.
Progress Center. When is that scheduled?
I believe that's scheduled for the 25th. Mike, can you confirm? Yes, the 25th of January.
Okay. All right. All right. Well, Ms. Day, you're saying once a week. Is that what you're recommending?
I would recommend a once a week visit. I know that it's going to be difficult. This is a young child with a lot of emotional challenges and some pretty significant health challenges. So I think she needs to have contact, and it is going to be tough. But she's gone 3 months almost without seeing her mom, and I think that's a concern.
All right, counsel, anything further?
Nothing further to add at this point. Thank you.
From us, Your Honor, we would like to do the Progress Center appointment before a visitation. We also need a little bit of time to figure out who would be a supervisor.
So at this point, I think it's important, especially with a young child, that parents have contact unless there is an issue. I understand the substance abuse being an issue. At the same time, if it's supervised, then I think that would be appropriate. So in regard to the mother, I do want the mother to UA. I don't know if a hair follicle test has been done, except if the admission's been made. I guess there's no point in that. But I would want a clean UA before having the visitation. So I will order. I don't want to wait till the end of the month and then wait another time. So I do want, and again, just expect that child's going to have issues, which I think it's good going to the Progress Center and addressing that. In regard to who that third party is, I'd prefer that the attorneys try to work out who that is rather than me naming somebody, because I'm going to get to one of the professional places that supervise, and that's going to be costly. So I'd rather see if there's a third party that the parties can agree on. It will not be somebody in the home of the mother or the alleged father, not quite sure where that's at, but as to who that person would be, wouldn't be somebody in the home. So it needs to be at a neutral place where the visits occur, be it the library or some other place where there's some point of entertainment for a young child. I guess we don't have any of the fast food places with playgrounds anymore.
No, but we do have the location inside the mall that is segregated for ages. So there's a place for younger children to be.
Okay. All right. And that would be fine. Something like that is what I'm thinking of. Where am I? Please mute your connections. I'm hearing something. I'm not. Oh, thank you. Okay, so that's what I'm going to order once a week. I just want it for an hour. I know that doesn't sound like a lot, but I want to reestablish the visitation and just have a short time. It is a young child, so an hour for a young child seems like a long time for that child. So an hour once a week by an agreed third party at a point where the child has something to entertain and do. That place in the mall sounds like a good option, but I'll leave it to council to figure out who that supervisor is going to be. If not, then it'll be brought back on and I'll decide. Meanwhile, I'll go ahead and extend the emergency guardianship appointment for 30 days and allow Ms. Day to get her investigation done. That will be helpful with having the child go to the appointment at the end of the month. I think that would provide some information for Ms. Day as well. And then the mother should go ahead and get a substance abuse evaluation with input. I don't know if the DOC officer is the appropriate person or Ms. Day, but I'd like a third-party input in regard to the substance abuse.
Your Honor, may we request with the extension of the order that the restraining order currently in place for Katrina also include Jack Carnahan, as he has shown up at my client's property more than once, and we just would like to add him to the restraining order if that is okay with you.
Any objections, sir?
Yes, objection. There was one instance when this first all started that we had a problem. Since then, there hasn't been any problems with Mr. Vors or being around him or coming around him or trying to find him or doing anything. There was one incident when this thing first began. So I really don't see what the need there is. I'm still wanting to know why I was included and scratched off and then included in this whole ordeal.
I'm not sure, sir, and I'm not going to get into that right now. So when you talk to the guardian ad litem, Miss Day, do you look into whether alleged or what's your part?
Yes.
Okay.
So my understanding is an acknowledgement has been completed by the parents, by Mr. Carnahan and mom, and has been filed. So we're waiting for that to kind of make its way through the process, but it is establishing him by acknowledgement. I don't know if that's going to be challenged in the future based on DNA or request for that. I don't know, but there is an acknowledgement in place, and that's working its way through the Department of Records.
Okay. So once that's done and you're established to be the father, just remind me the next court hearing that we'll address about getting an attorney for you. So we'll address it at the next hearing.
Your Honor, I'm already on the birth certificate. Didn't we file a copy?
Yeah,
we filed a copy of it in this case. That I am acknowledged as the father of Jessica. So. And it's not about making it go through the record. It's already there. You should have it right in front of you.
We served it to Michael too.
And we served it to Michael.
So Ms. Day, have you seen that? You're muted.
Sorry, I have not seen that yet, but I believe it has been filed. I will review that. I just met with the parents and learned that this week. So I haven't had a chance to go back through Odyssey and see if that's been filed and or sealed.
All right. So, sir, there's a process. I know you may not agree with it, but there's a process we need to go through. We're going through it to make sure all the I's are dotted, T's are crossed. And just remind me at the next hearing, and we'll go through the issue in regard to getting an attorney. Okay?
Can he see his daughter during the visitation?
So at this point, I've only addressed it for you until I get more information in regard to dad. I won't be doing that. We'll address those things at the next court hearing, but that will need to be his request and his conversation. Okay. So at this point, the visitation is just for mom.
Thank you, Your Honor. I appreciate it.
Okay. All right. That concludes the matter for today.
All right. Thank you. Thank you, Your Honor.
Your Honor, may I clarify what your answer was to my question about adding Mr. Carnahan to the restraining order? For this?
Oh, I apologize. I didn't answer. Let me answer that. Sounds like there have been issues. So for that reason, I will add him at this time.
Thank you, Your Honor. And would you like our office to prepare the order?
If you would, please.
Yes. And we'll get that over to you this afternoon.
The children.
Thank you.
And that matter's ready, Your Honor.
And Donald Lisa on behalf of the mother, Shannon Murphy.
Okay. And do I have either parent here? Not hearing anything.
And I've received no response, Your Honor.
You have not?
As well, Your Honor.
I have not.
Donna Harrington, the guardian.
Oh, thank you. All right. So with that, Ms. Winkles, what are you requesting at this point?
Attorney fees are not probably going to help in this case, given that father doesn't have the money and was originally appointed counsel. Last time I spoke to father was for CR26I, who cursed at me and hung up on me. At that point, I've received no other contact. I've called him. I think sanctions need to be given in this case because I can't set this I can't bring it to trial if dad is not going to participate. And if he does participate, great. If he doesn't participate, we'll need to default him out because as Mr. Esau and I know, mom and I are very close to settling this. And the case would be over at that point. So what I'd ask for is the court to come up with a sanction that is doable, given that dad, normally it's attorney fees, dad doesn't have money. And then I'd ask for a review. I will serve him with everything from this docket today and the docket sheet for the next review, but I'm not sure what the court wants to do when attorney fees aren't sufficient as sort of I guess not really punitive, but to light a fire under data. I'm not sure what Your Honor wants to order for that.
So, and there are a couple of things that I can think of. One is that to strike pleadings, but they don't really do pleadings like they would in a domestic, so that doesn't really work. The other is to not allow any testimony from father as it relates to those issues that are covered by the interrogatories. So that's another option. So to me, that comes to mind. So just so the dad understands the impact of not responding, I would like it basically to provide 2 more weeks of that he can turn over the information. Otherwise, he will be restricted from testifying as to any information that was contained in or requested under the interrogatories.
All right, that works for me, Your Honor. What I'll do is I'll go ahead and do an order and a docket notice and all of that, and get to Your Honor to sign, and then I'll go ahead and serve him with those as well via email. And we'll try to get personal service, but if not, we'll serve him by mail as well.
Okay. All right. So, Mr. Esau, anything from you today?
No objections, Your Honor, and nothing from us further.
Okay. All right. That concludes the matter for today. Oh, we do have I should ask, the guardian is here, not represented. So any objections from you?
No, Your Honor. Thank you.
All right. Thank you. All right. That concludes that matter. Anyone present on that matter?
Good morning, Your Honor. Christine Dow representing the guardian, Jamie West.
Good morning, Your Honor. Delana Jones here on behalf of respondent mother Marlene Melton, who is also present on the Zoom platform this morning.
Okay, thank you.
And Your Honor, my client, Ms. West, is also present. I am not seeing Ms. Farr, and I believe this hearing was to review her visitor's report. She's appointed as a court visitor. Yeah. I believe Ms. Jones and I were both in contact with her yesterday. She said that she was unable to complete her report by this date, but she has a very heavy caseload. I understand that, but she did say that she would try to get it out to us in the next few days. So I would suggest that we kick this out a couple of weeks. I would ask her if that were sufficient, but I'm not seeing her.
That sounds most appropriate. That's what I noted, that it was to review where she was with her report. So if there's no objection, that seems appropriate to just set it over a couple of weeks, and hopefully she can have a report done. So that would be over to February 1 at 10:30 to hopefully have the report filed with the court.
And Your Honor, I'll submit we're operating on continued ex parte temporary orders here. Okay. I'll submit the updated order today.
Okay.
Your signature.
Sounds good.
And Sherry Farr is the guardian ad litem in this matter, and I do not see her on the hearing as well. And we are waiting on the guardian ad litem's reports in this matter. We're also waiting on a statement from DCYF that there are no CPS records before a final order can be entered. Last I did speak to Ms. Farr, she is recommending that petition be granted as requested. And there are no objections, and all parties are in agreement to the petitioner's appointment as guardian for the minor children. So Judge Warning at the last hearing granted authority for us to enter final orders on an ex parte basis, and this was set for review. So we're going to request continued authority once the guardian ad litem report is filed and properly served to submit orders on an ex parte basis, but then still requesting that this be set for a future review hearing in case orders are not entered ex parte.
Anyone else on this matter? I'm not hearing anyone. So how far do you want to set it out? A couple of weeks or?
Well, I'm thinking if we can set this out to February 15th, that will allow Sherry Farr's reports to be due 10 days prior to the hearing. So February 5th would be a firm deadline for her reports to be filed with the court and served. Hopefully we could just enter the final order ex parte. If not, I'll mail it up for entry at the final hearing on the 15th.
Okay. All right. And I just heard that from Ms. Winkles, that apparently when she spoke to her yesterday, she was having troubles with weather-related internet power issues. So that's probably what's going on. So February 5th?
For the due date of Ms. Farr's guardian ad litem's reports.
Okay.
And then the review hearing set on the 15th if we don't get orders entered.
All right, just give me an order.
This is just a regular petition, so we don't have emergency order in place. So just setting this over.
Okay. I think we need something though to set that date for her. So just a general order would be good.
I can do that, Your Honor.
All right, thank you.
Thank you.
Erin Winkles appearing on behalf of the petitioner, Scott Aldrich.
Okay.
And I believe Mr. Radcliffe, who is now the father based on genetic testing and through a DCS action, is also here. And appears Lillian Aldrich, who is the mother, is also here.
Miles, I didn't say it loud.
Okay, Mr. Radcliffe, I'm going to mute you. I'm not sure who's talking off on the side, but it needs to stop. All right. Anyone else on this matter? Okay. All right. So, Ms. Winkles, go ahead.
Yes, Your Honor. This is kind of a strange one. Miles Radcliffe was the father. There was a DNA test done. He was not included in the original petition. So I guess he was included. He consented, but then they found out he wasn't on the birth certificate. So then the Department of Child Support obviously did what they were going to do, the state. They did get him on the birth certificate. So we're here now, given that mom is the only one that's under this guardianship and the rules of the guardianship. We normally let dad go ahead and do this and do a motion, but we do want to make sure that there's no confusion when it comes to the school or the police or any of those things. So we did want to include dad on the guardianship. He has not responded to the best of my knowledge. I'm assuming Mr. Gaudet represented him in another matter. I'm assuming he's going to be asking for counsel and to set this over today, but I'll let him speak.
Okay. So, Mr. Radcliffe, go ahead and unmute.
What's the thing I filled out? Declaration. I filled out a declaration and I turned it in today because I really didn't know what it was about.
Okay.
I was misinformed about what it was about.
Mr. Radcliffe, I'm going to stop you for just a minute. Let me ask you this. Do you want to have an attorney appointed to represent you?
Yes.
Okay. So can you give me an idea about what your monthly income is, just a general amount? Are you receiving any benefits or anything like that?
I literally just got a septic job. And so it's only part-time, so it'll probably be like, I don't know, probably like $500 a week.
Okay. All right. You would qualify. So I'll go ahead and appoint an attorney for you. Sounds like maybe Mr. Gaudet had represented you before. Is that right?
Yeah, and if I could get him, that'd be really cool.
Okay. I don't know if he'll take any more cases right now, but because of that, I will go ahead and have my assistant reach out to him to see if he would take the case. So it takes a bit to locate an attorney, so I can't tell you who that's going to be today. But would you like to talk to your attorney before we do anything more today?
Yeah.
Okay. All right. All right, so I'll go ahead and do that. We'll try to get somebody on board for that. And then we have, looks like mom is on here too. Lillian Aldrich, is that right?
Yes, and mom's already consented in the past, so that's the minor guardianship. She has visitation.
Okay,
already.
All right, good. All right, so has a guardian ad litem been appointed? Are you wanting to go ahead and do that, or?
Sherry Farr is already the guardian ad litem in this, and she's still on. She was not discharged, which is why I actually spoke to her yesterday. So that's how I know about her internet issues. So I'm assuming that's why she's not here. And so I can just let her know that Mr. Radcliffe's been appointed counsel.
Okay. All right. So my thought is to go ahead and set this over to February 1, so we have a chance to get an attorney for Mr. Radcliffe. And Mr. Radcliffe, just to find out, is your contact information in the court file?
Yeah, I just filled out what is it? A declaration. It has my number and my address and everything on it.
Okay.
And,
okay, super. All right, that's what I need, and I just want to make sure that your attorney can get a hold of you.
Yeah. Can I just ask something real quick?
Go ahead.
I have not been able to see my daughter because whatever the guardianship said that I wasn't aware of, I have not been able to contact my daughter, call my daughter, see my daughter, have anything with my daughter. It's been like, what, 8 months now? And I'm not expecting like, oh yeah, you get it overnight. I just want to know if I can visit my daughter in any way.
So at this time, I don't know who's talking off on the side. Please stop. Okay. You're not an attorney. I can't have you telling him what to say. So, sir, you're going to get an attorney, and I'd like you to talk to your attorney about that. I don't know enough today to say, yes, you can, or no, you can't. I don't know enough. And that's where the guardian ad litem, she couldn't be here today, and she'll make contact with you too. Do you understand what a guardian ad litem is?
Yeah, isn't that the person that comes to like see the house or whatever they stay at?
Exactly. Exactly. So her name is Sherry Farr is her name, and you may be hearing from her as well. Okay. So, but let's go ahead and get an attorney on board. I'm not saying yes or no to visits. I just don't have information, and things can't happen that quickly without my information being in front of me. Okay.
All right.
So we'll look at that later, but for right now, that's not going to happen today. Okay.
And Your Honor, I just asked that the emergency that's in place, I think we asked for an emergency restraining order just until the hearing. I asked that continues since we don't know anything either. And I know Dad has an active warrant through Kelso PD right now. So we just want to make sure that all that is cleared up, and we can go and have Sherry Farr do the investigation.
Wait, pause. I'm on drug court. I just met with Candace, my drug court counselor, Judge Haan. I'm sure you're aware of it. Anything. What is the warrant for? I have no warrant.
I don't have any information today, Mr. Radcliffe. So we're not going to do this today. I'm going to extend the orders that have been put into place. Doesn't mean that they'll keep going, but I want you to get an attorney on board, and then we'll, do what we need to do from there. Okay. It's not a done deal, but we just can't do it today. We can't just show up in court and start asking for things. It doesn't work that way. Okay. Yeah. Okay. All right. But as far as today, I think we've done everything we're going to do today. I'm glad you're here today, Mr. Radcliffe. That's really good. Reach out. Sherry Farr is the person that you need to talk to. Ms. Winkles, can you provide Mr. Radcliffe her contact number?
Absolutely. And I'll also go ahead and send out the JIS, because Mr. Radcliffe, half these things these people don't know about anyway, and they're from 5 years ago. So I'll go ahead and provide him Ms. Farr's information, and also provide him the JIS statement so that he can take care of those things that might be just not swept up.
All right. All right. That takes care of things for today. Okay.
All right. Thank you, Your Honor.
All right.